Are you ready? Let's roll, nerds. Come on. Mr. Simon, how are you? Great to see you. Ready? Who do you have?
I am here on...
Okay, wait. Did you catch that? The defense just cited Harden versus State, which actually overrules previous case law on traffic stops for failing to maintain a lane. Basically, they're saying that swerving a little isn't enough to pull someone over, unless it's actually dangerous. That's a huge deal. Do you think weaving should always be enough for a stop? Let us know in the comments.
Robert Anderson, Your Honor.
Page 1, Anderson, come on up.
Mr. Simon, great to see you, lady.
Good to see you, man. You doing good?
Yeah, you know, working. Good morning, Mr. Anderson. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 8th, 2024, the officer conducted a traffic stop on the defendant's motor vehicle after observing it failed to maintain a single lane while traveling west on Jester Boulevard. The officer observed the defendant constantly veering out of the lane and going into the second lane. The officer observed the defendant to be the driver and sole occupant of the vehicle, and while speaking to the defendant, the officer observed a strong odor of an alcoholic beverage and bloodshot eyes.
Legal tip time. Not all case law is created equal. Judges aren't bound by decisions unless they come from a higher court in their jurisdiction. So while the defense is bringing some serious receipts, Judge Fleer doesn't have to follow them. He can take them as guidance, but he's not handcuffed by them. That adds a layer of tension to this whole debate.
The defendant was struggling while exiting the car and was swaying back and forth while speaking to the officer. Standard field sobriety tests were performed, HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The DIC was read, but the defendant refused and a blood search warrant was drawn and executed.
Your Honor, may I make argument, Judge?
Sure.
Thank you, Judge. The sole reason for the stop in this case was failure to maintain a single lane. Most recent case law on this is Harden v. State. And in that case, it overturned even Leming. And they went as far to say is that failure to maintain a single lane is not probable cause for a stop.
Well, I get it, right? You have to dictate more than just saying failure to maintain.
Yeah,
You have to have provide
a danger to another vehicle. There's other vehicles around. And this is on TC Jester Boulevard, a very sparse road at night.
So what were the indicative facts?
I'm opening the office.
Yes, Your Honor, we're looking at the office report.
I mean, obviously, we don't have any body cam, dash cam, so I'm not,
Well, right, but this is just a mere probable cause. I need enough of a statement.
This part's crucial. The officer's report claims the driver was swaying, had bloodshot eyes, and reeked of alcohol. But here's the kicker. The stop only happened because the car was weaving. If the initial stop wasn't justified, all that juicy evidence might be tossed out. Yeah, fruit of the poisonous tree, anyone?
From the officer in the DIMS saying how he justified pulling the car over in light of failure to maintain a single lane. The weaving statute. I mean, do you need a bit of time? If you want to reconvene in like maybe 30
Yes,
minutes,
Judge.
it's fine.
My offense report's not voting for some reason, so.
If we may have a little bit more time.
Mr. Simon, do you have somewhere else to go?
I have Fort Bend to go to. Can I go to Fort
Well,
Bend?
That's going to take hours. If you want to, yes, because you can always zoom in. I have Zoom for you.
I'll wait.
So perhaps maybe, 15 minutes, give them time to look at the OR.
Yes,
All right,
Judge.
just take a seat for a minute, Mr. Anderson. We'll come back. Are you ready with Mr. Simon?
Yes, sir.
Are you ready?
Yeah, I'm ready.
Okay, come on.
Can I bring him back up?
No,
All right.
I don't think it's necessary. Can you read it to me again?
PC?
Yeah.
On 12/8/24, officers conducted a traffic stop on the defendant's motor vehicle after observing it failed to maintain a single lane while traveling westbound on TC Jester Boulevard. Officers observed the defendant constantly veering out of lane 1 and going into lane 2. Officers observed the defendant to be the driver and the sole occupant of the motor vehicle. While speaking with the defendant, officers observed strong odor of alcoholic beverage and bloodshot glassy eyes. Defendant was struggling while exiting the car.
That's it. I mean, the crux of the argument is the stop, right? So
Judge.
I guess in this instance, he says that he's veering from one lane to the other constantly.
Yes, Judge. And I understand the issue with Harding, but it's distinguishable. From Harding.
I need to read it first, but
Okay.
what does constantly mean?
I would imagine back and forth.
Okay, does one time, I guess it's at least
we
two
don't have that
times, right?
information,
Well,
but
even in Rodriguez, which was the original case that kind of made these stops not probable cause, in Rodriguez, the person that Rodriguez actually veered out of his lane into the shoulder 6 or 7 times. And they found that not to be probable cause because there was no other vehicles around. And in this case, there's no other vehicles around. I think that's the biggest factor that we look at, or courts look at.
I don't think that that's necessarily it though, because you could be a danger to yourself.
Here's where it starts to unravel a bit. The word constantly is doing some heavy lifting in the police report. But what does constantly even mean? 3 times? 10 times? Courts don't like vague language, especially when someone's rights are on the line. This could be a make or break detail.
and
Right.
I don't think that
So
that's
I mean,
dispositive.
the fact that is there other car, I don't think that's dispositive.
Okay, fair enough.
But
Fair enough.
my concern is, he says constantly.
Yeah.
Yes,
What
Judge.
does that mean?
Judge, it's unclear based on the OR. I believe we attempted to call the officer right now who may be a night shift officer and is off right now. We were not able to speak to him, but I do believe that there is sufficient probable cause. In Harden, Morgan and I looked at the case. In that case, the right rear tire of the U-Haul truck that the defendant was driving touched and drove on the striped line marking the right side of her center lane. It doesn't even say that she crossed over, she was driving on the line. These are completely different facts. In this one, the defendant here was constantly veering in and out from lane 1 to lane 2. You know, she was a danger to her, he was a danger to himself, he was a danger to the officer that was driving behind him. I don't know if there were any other cars around, Judge. I do believe that there is sufficient probable cause to just.
Okay, so I guess, Mr. Saman, I need to read what it is, the case, at least. You know, if you want me to, I'm happy to. But I need a little bit more time.
Yeah, there's also Rodriguez v. United States. That's one to look at in which.
I mean, I need to look at both of those, read them, and then I need them to see it.
Also cited when Harden, and I think that one would be valuable for you to look at as well,
Okay.
Judge.
So I guess, do you want to go, and then you want to zoom on?
This prosecutor is clearly pushing back hard, saying this isn't like the Harden case at all, in their version. The driver wasn't just touching lines. They were weaving like a snake down an empty road. But again, if no other cars were around, was it dangerous? That's the legal gray zone they're fighting over.
Whatever you want me to do, Judge.
Yeah, I want to go through the arraignments that way, because this can be a little more time.
I don't mind coming back.
Okay, yeah.
You can.
For what it's worth, remember, like, we can't try a case now, but this is just a mere probable cause. So
I fully appreciate
you know,
that.
so-
I just don't think that our probable cause is articulated in this case.
all right, go. You know what? Do me a favor. Leave me your cell phone just in case, will you? And then I'm live streaming, so don't say anything out loud. But leave it to me.
Yeah, sure.
When we're done, I'll reach out to you. I'll text you, and then wherever you are, either we can zoom in, or if you're still here, then we can do it here.
Thank you, Judge.
Okay. Do you have copies of the case so I can at least see it or a cite? Sure. Do it.
Thank you, Judge.
Appreciate it.
Whenever I
Happy to do it.
4 minutes, I'll do that.
Yeah. Okay.
And I'll also email you both our cases as well.
Thank you.
Okay. For sure.
And we can leave. You can leave.
No. Because if I find probable cause, I have to do bond conditions.
Oh, okay.
You know, you can. He
Okay.
can't.
Okay.
Yes, they're still.
So, Mr. Saman,
Yes, Your Honor.
the cases that you provide me, like, I think the distinguishing thing is that all of them have like one instance
Well,
of
not the Hernandez, which is kind of the genesis of all these, and that one.
Hernandez is one time.
No, Hernandez is 4 to 5 times, I think, is what they stated.
I'll point out that Hernandez was rejected by the court in Leming as well.
Yeah, but then Leming was rejected by.
Leming was not
Harden.
rejected by Harden. They
said
disagreed
you-
with the state's application, of it in Harden, but it was not overruled or rejected.
Well, I think Harden.
Hold on.
Sorry, Leming was rejected on point because there were other factors that Leming brought up, such as the danger to other vehicles.
It's a totality argument is what the court is stating in Harden. It says, thus, even under the circumstances in which a motorist crosses from one lane to another without necessarily raising a safety concern, that behavior can still be considered along with other facts to provide reasonable suspicion to stop for
Sure.
suspicion of driving while intoxicated.
Of course. I mean, you look at the entirety of everything to see, hey, is there enough to justify the stop, right?
I agree.
On a failure, of course, that one is just time that's insufficient, right? And I think there's enough cases to say that out there. But when you have multiple times, I think at that point, that may, because they could be a potentially danger to themselves as well. Here, the only problem, my problem here is he says, what's the one word he uses?
Constantly.
Constantly.
And I understand.
Constantly is conclusory.
I understand he
is.
could have been more specific, Judge, but I mean, this is a probable cause matter. And the fact that he even put constantly rather than failure to maintain a single lane. Because I mean, I've seen it where it says traffic stop initiated for failure to maintain a single lane. You know, so he did take the
I mean,
time
that's
to put
so
constant.
conclusory, right?
Right.
And I mean, constantly definitely indicates more than one, right? But I don't know. What does constantly mean?
It doesn't, and like you said, it is conclusory. And unfortunately, I think that we have to go by what is stated in the probable cause statement. And in this
Sure.
case, we don't know. And if there's a question, I think it has to go on the side of the defendant.
Judge, I think we have enough for probable cause. He said constantly, I mean, he still indicated.
Read it word for word again, one more time, please.
And there it is. The judge says if there's any ambiguity in the probable cause, it has to go in favor of the defendant. That's Constitutional Law 101. But do you think that's fair? Shouldn't officers get the benefit of the doubt too? Hit the comments. We want to hear what you think.
Officers conducted traffic stop on defendant's motor vehicle after observing it failed to maintain a single lane while traveling westbound on TC Jester. Officer observed defendant constantly veering out of lane 1 and going into lane 2.
He also states, I'll go further because I actually went into the probable cause that was written up for the blood warrant, and in the probable cause for the blood warrant, it says almost strikes the curb.
I feel like that makes it worse, actually.
Well, I don't think so. I don't think so because I think almost striking the curb is also
Because
like.
he's now swerving between 1 and 2 lanes and he's going back over and almost hitting the curb.
It is a totality, so that would be an additional
That's
fact. the
veering.
officer